informed decisions. And candidly, we don't have it. This year, as many as 9 states may consider recreational marijuana legislation, either decriminalization or legalization. These states must be able to draw upon lessons learned from existing laws. And the department has been asked to do it, to provide that, but hasn't. So continued failure to correct accurate data and share it with the public in a way that's understandable is quite simply unacceptable. I was therefore pleased that the department agreed with the report's recommendations that it should document its process to monitor state marijuana legalization and share this with appropriate components. I also want to say that while I'm happy that United States Attorney Wagner is here, and I'd like to thank him for his work, I'm disappointed that the Justice Department chose not to send a witness that is directly responsible for monitoring the effects of legalization or shaping the department's overall marijuana policy. In my view, it appears that the department is simply trying not to live up to what its responsibility is. So despite this, I look forward to hearing from each of the witnesses today and learning about how Justice plans to implement the report's recommendations moving forward. And Mr. Chairman, my suggestion is if it takes legislation, we should do legislation. But if you have the huge increase in traffic deaths and you have the huge increase in 12 to 17-year-olds using marijuana, it seems to me we need to get some accurate data so that these 9 states know what they're doing when they consider legalization.
Well, we'll keep in touch with you on that point.
Thank you.
I would introduce our panel. Mr. Wagner has served as U.S. Attorney, Eastern District, California, since 2009. Currently serves on the Attorney General's Advisory Committee and is a graduate of New York University School of Law, Dartmouth College. Second witness, Jennifer Grover, currently serves as Director of GAO's Homeland Security and Justice Team. In that capacity, she led the team that wrote the GAO report that is the focus of this hearing. Ms. Grover has worked at GAO since 1991. She has a master's degree in public policy and administration from the University of Wisconsin and a bachelor's degree in political science. Normally, have you start the way I introduced you, but is that or should we have Ms. Grover go forward? Okay. Go ahead, Mr. Wagner. Thank you very much, both of you.
Thank you, Chairman Grassley, Co-Chairman Feinstein, Senator Whitehouse. On behalf of the United States Department of Justice, I appreciate the opportunity to testify today regarding marijuana enforcement and state marijuana legalization efforts. I'm Benjamin Wagner, the U.S. Attorney for the Eastern District of California. I joined the office in 1992, and my first assignment was in the Narcotics and Violent Crime Unit, where I served for several years and personally prosecuted drug trafficking and violent crime cases. I've been with the Eastern District ever since, and have been privileged to serve as the U.S. Attorney for the past 6.5 years, working alongside dedicated career prosecutors and agents, as well as other federal, state, and local law enforcement partners. In my testimony today, I hope to be able to provide the caucus with information about the department's policies regarding marijuana enforcement and my own experience enforcing federal marijuana laws in a state that recognizes medical marijuana. I will also discuss the recent GAO report regarding state marijuana legalization and the 2 report recommendations in which the department has concurred. Although we currently review data from a variety of sources, we agree with the GAO that having a more centralized repository will be helpful in making policy decisions and will inform our investigations and prosecutions. I would like to start by noting that the federal government and the states traditionally have worked as partners in the field of drug enforcement and continue to do so. Federal law enforcement historically has targeted large-scale, sophisticated drug traffickers and organizations, while state and local authorities generally have directed their enforcement resources against a broader range of activity under their state laws, including more localized and lower-level drug activity. Changes in state laws relating to marijuana enforcement have affected this environment in some states. but the department continues to work with its state and local partners to address the major public safety threats posed by trafficking in narcotics, including marijuana, and to ensure that our efforts are mutually supportive. In August 2013, former Deputy Attorney General James Cole issued guidance to all U.S. attorneys regarding marijuana enforcement. The Cole memo directs prosecutors to continue to fully investigate and prosecute marijuana cases that implicate any of 8 enumerated federal enforcement priorities, including preventing distribution to minors, grows on public lands, funding of organized crime, and other important federal interests. The Cole memo has been helpful in focusing how to best utilize our limited resources to pursue cases involving the most serious threats posed by marijuana-related activities. The Cole memo also articulates the department's expectation that states which have laws that authorize marijuana production and distribution must implement strong and effective regulatory and enforcement systems to fully protect against the public health and safety harms that are the focus of our marijuana enforcement priorities. In those cases where marijuana-related conduct does not interfere with federal priorities, we expect our state and local partners to address those cases consistent with the traditional federal-state approach to drug enforcement. Where such conduct does interfere with federal priorities, we can and will act. Finally, it's important to remember that marijuana remains illegal under federal law, and nothing in the Cole memo alters our enforcement authority. In my district, the Eastern District of California, where we have vast federal lands, we prosecute a significant number of defendants each year who are arrested while cultivating marijuana on public lands, which is one of the Cole memo enforcement priorities. In my district, we are also focusing on marijuana enforcement efforts on interstate trafficking. We work closely with DEA and other agencies to identify and prosecute interstate traffickers and to interdict marijuana and drug proceeds. Over the last 2 years, working with the U.S. Postal Inspection Service, we have executed over 100 search warrants on parcels intercepted in the U.S. mail, seizing large amounts of marijuana and cash. And we also assist other jurisdictions in gathering evidence in our district to prosecute interstate marijuana traffickers in those jurisdictions. Just last week, we announced the arrest of a significant interstate marijuana trafficker based in my district. Using the dark net to transact business, he was alleged to have shipped marijuana and also cocaine to locations all over the United States, receiving payment in Bitcoin. 2 weeks ago, we worked with the U.S. Attorney's Office in the Middle District of Pennsylvania, which indicted 4 residents of my district for trafficking marijuana from California to Pennsylvania. Turning to the recent GAO report, the department agrees with the report's recommendations that we document a plan specifying the process for monitoring the effects of marijuana legalization under state law and share the plan with department components. We appreciate the considerable effort and time GAO spent on this review. I personally met with GAO officials during their review, and I appreciated their thoughtful and collaborative approach. In accordance with the GAO recommendations, the Office of the Deputy Attorney General has directed the development of a publicly accessible web portal to serve as a repository of data. This will help inform the judgments made by the department as it makes resource and enforcement decisions regarding marijuana-related criminal and civil enforcement actions. We will identify data sources within the department, as well as from other federal, state, and local agencies, law enforcement, and public health organizations. Although we are in the early stages of development, I can assure you this is a priority for the department, and we will be happy to keep the caucus apprised of our progress. Thank you for this opportunity to testify before the Senate Caucus on International Narcotics Control, and I would be pleased to answer any questions.
Thank you, Mr. Wagner. Now, Ms. Grover.
Good morning, Chairman Grassley, Co-Chairman Feinstein. I'm pleased to be here to discuss the Department of Justice's approach for monitoring the effects of state marijuana laws. The primary message of my testimony this morning is that the department should document its monitoring approach, including how it will use the data that it's considering to evaluate the effects of state marijuana legalization relative to the federal enforcement priorities, to better ensure that monitoring is being carried out as intended by the department. We've already talked this morning about how in 2012, Colorado and Washington passed ballot initiatives that legalized marijuana for recreational use. And in turn, the department, which is responsible for enforcing the Controlled Substances Act, updated its marijuana enforcement guidance. In that guidance, the department emphasized that states permitting marijuana use must also implement strong and effective regulatory and enforcement systems to make sure that the federal enforcement priorities are protected. The department went on to note that if the state enforcement efforts didn't adequately protect the priorities that had been outlined in the guidance, that the federal government may challenge the state regulatory structures in addition to conducting this specific enforcement action. But to be able to follow through on this enforcement approach, the department must have and effectively implement mechanisms of its own for effectively monitoring threats against those priorities. DOJ told us that they have two main approaches. The first approach is through their ongoing law enforcement activity. In the states, the U.S. attorneys told us that they monitor and prosecute cases that involve the enforcement priorities. They also consult with their partners in state and local law enforcement to address concerns about the effects of marijuana legalization. And the second approach is through coordination and data monitoring. Department officials told us that they collaborate with and assess information from DOJ components and other federal agencies. For example, they reported using data sources such as the DEA's National Drug Threat Assessments and the U.S. Attorney's Case Management System, and by participating in meetings with other federal officials to discuss the effects of state marijuana legalization. We acknowledge that department officials have reached out to coordinate with state and federal officials. However, we found that the department had not prepared a formal written plan, nor did DOJ share any details about how it planned to monitor the effects of state legalization of marijuana. For example, department officials did not specify the range of data they would consider, nor how the data would be used to evaluate the effects of state marijuana legalization relative to the enforcement priorities. At the time, department officials told us that they did not see a benefit in preparing a formal written plan. We're pleased that they have decided to document their approach, as we believe that it will have several good effects. Because GAO has found that a specific written plan generally provides assurances that activities actually occur as intended, we recommended that the department should go ahead and prepare this type of plan, and that it should include, first of all, the data that they will be using, and potential limitations of the data, so that the department can be assured that their data that they're using is complete, accurate, reliable, and appropriate for the purpose that they're intending to use it. And second, how that data and other information sources will be used for monitoring. DOJ also concurred with this recommendation. We also noted that having this type of a formal written plan provides a way for the department to retain and communicate organizational knowledge. Thus, sharing a written plan with the appropriate DOJ components could improve the overall effort. For example, the department cited reliance on the U.S. Attorney's Case Management System, known as LIONS, that we subsequently learned was likely limited in its use for identifying marijuana-related enforcement cases. By sharing its monitoring plan, the department will be better able to ensure that it's using data in the most appropriate way, and the department has concurred with this recommendation. Should the department make the changes we've recommended, it will be better positioned to ensure the protection of federal enforcement priorities and overall public health and safety. Thank you for the opportunity to testify, and I look forward to your questions.
Senator Feinstein, you said you had to go at 11. Do you want to go first?
Oh, that's very kind of you. Thank you very much. Ms. Grover, let me just say I agree with everything you said, and I thank you for that. The 8 priority enforcement areas of the Cole memo that are on page 11 of the memo, let me quickly run through them. Each one begins with one word, and it's preventing the distribution of marijuana to minors. Big problem, obviously, from just that one number of the increased percent from age 12 to 17 that are now using marijuana. Preventing revenue from the sale of marijuana from going to criminal enterprises and cartels. Preventing the diversion of marijuana from states where it's illegal under state law in some form to other states. Preventing state-authorized marijuana activity from being used as a cover for the trafficking of other drugs. Preventing violence and the use of firearms in the cultivation and distribution of marijuana. Big problem in California. preventing drug driving and the exacerbation of other public health consequences associated with marijuana use, preventing the growth of marijuana on public lands, and finally, preventing marijuana possession on use on federal property. Mr. Wagner, will the department use these 8 priorities and carry them out? Could you turn on your mic?
Sorry. Absolutely, we will. And I know in my office and in talking to my fellow U.S. attorneys across the country, we very much look to those priorities in making enforcement decisions, not only who to prosecute, but in our discussions with the DEA, with our state and local law enforcement, which is a constant discussion between U.S. attorneys and our state and local law enforcement partners. We talk about those priorities, about targeting our enforcement to those priorities, and so that is very much in our minds constantly when we focus on marijuana enforcement.
And will you do the required data collection and make the report available to the public in at least one place?
Our plan is to collect data from a number of sources, and to the extent it is publicly available data, obviously some internal law enforcement data, some of it will be, I think, inward-looking law enforcement data, but we plan on capturing public data from a number of different sources, putting it in a central repository that will be a web portal that is available to the public, yes.
Well, as you know, our state may very well move to legalize, and it's 40+ million people. And with the increase that's here in the use of marijuana from 12 to 17-year-olds having escalated dramatically in the states that have legalized marijuana, it raises a huge concern as to driving statistics, which are reflected also in Colorado's numbers, which are accidents caused by marijuana use. What is your view of what we might be able to do to see that the accurate information is provided and that justice is willing to carry out its responsibility?
Well, we are going to capture data from as many different reliable sources as we can. One of the things that we have learned in the course of this is that some states have more reliable data than others. I think, as Ms. Grover indicated, we have to be careful that we are relying on data that's reliable. Some states don't have effective baseline data, so if they don't have data sort of before data, then the after data is of questionable reliability, but we want to reach out and collect data from our federal agencies, from state public health organizations, from the ONDCP, and collect that all in a central place so that we can have a better idea of trends as they're happening.
Thank you. Thank you, Mr. Chairman.
Yeah. Thank you. We're going to put some charts up here to show the direction of some of the harm that has come from this legalization. So I'd ask you to refer to that. It's a Rocky Mountain High Intensity Drug Trafficking Area Report, September 2015. Here you can see the number of marijuana-related hospitalizations in Colorado, and it has dramatically increased, including an increase of 70% between 2012 and 2014. The Cole Memorandum specifically states, quote, jurisdictions that have implemented systems that provide for regulation of marijuana activity must provide the necessary resources and demonstrate the willingness to enforce their laws and regulations in a manner that ensures they do not undermine federal enforcement priorities. So, question, preventing adverse public health consequences associated with marijuana use is a federal enforcement priority under this Cole Amendment. So, I hope you would agree that this chart reflects this priority as being undermined, and do you see it that way? If not, why not? And if so, why hasn't the Department of Justice taken action to challenge the state law?
I would agree that that data is alarming, and I will start off by saying that the U.S. Attorney's offices are acutely aware of the data and reports that are put out by the HIDAs. I know that my colleague in the District of Colorado is in touch constantly with the Rocky Mountain HIDA. I know in my own district, the Central Valley HIDA also collects data, and we are very in tune with the Central Valley HIDA. In fact, the HIDAs, as you know, Senator, are joint federal, state, local law enforcement. A lot of our marijuana prosecutions arise out of cases brought by the HIDA. I personally served as the vice chair and then as the chair of the HIDA. It's a rotating chair system, so we are very closely connected with them and with their data. To answer your question about this information and its use, certainly it's very alarming, and it's data that we, as the department, will take into account when we look at what sort of enforcement actions to take. I think it's important to realize that enforcement decisions are going to be informed by data, and more data is good, but they're not going to be dictated by data in the sense that enforcement decisions invariably look at a range of factors, look at the local environment, look at local law enforcement, their views, look at the prospects for success, look at what the likely result is of an enforcement action, and look at a range of factors, including, importantly, the sort of data that you're referring to.
Well, since you say yes, but obviously it's not enough yet to warrant challenging the law. Of course, this is why having metrics is very important. So follow-up question, how high would this graft have to go here to have the Department of Justice intervene to challenge state law? Would it be 15,000 hospitalizations, or you can pick anything out of a clear blue sky, 20,000?
Well, I don't think I don't think I can give you a number on that, and that's because the decision, as I mentioned, would not be solely based on the data. So with any enforcement decision, whether it's to bring a prosecution or to bring a civil case, you look at a range of factors, and that would certainly be true in Colorado. So one of the factors in Colorado, for example, is that it may be possible as a legal matter to challenge the regulatory regime that is in effect, but not to overturn the decriminalization of marijuana in that state. So if we brought an action which essentially took out the regulatory system for recreational marijuana, but left in place decriminalization, you may well have a situation which is worse than the status quo. Another similar factor is under Section 538 of the Omnibus Bill. The way the department reads that language, it prevents us from bringing actions to which would prevent a state from implementing its own medical marijuana system. So if we were to, for example, challenge the state regulatory system for recreational marijuana, but were prohibited from challenging the medical marijuana side, again, it may leave a more chaotic situation than we have now. So that's all by way of simply indicating that the decision whether or not to challenge a given regulatory regime is going to be informed by data, but not dictated by data.
Let's go on to another metric or another statistic we have. You can see in the next one that the number of marijuana-related emergency room visits in Colorado per year has increased more than 83% between 2012 and 2014. In 2014, it reached over 18,000 visits. So the question is similar. Doesn't this chart also reflect the same federal enforcement priority being undermined? Again, if not, why not? And if so, why hasn't the Department of Justice taken action to challenge the state law?
I think my answer would be largely the same, which is it is alarming data, and we would certainly, it's certainly something that we're concerned about and are keeping an eye on, and it will certainly inform a range of enforcement decisions, not only whether to bring a civil case, but what sort of resources to dedicate toward prosecutions in that area. So certainly it's valuable data and alarming, but I don't think it would necessarily by itself trigger any particular enforcement action.
I have a similar follow-up, but I think I'll get the same answer from you gave before, but I think then I would make a statement that this is why the metrics are so important. And then my last question will be in regard to the next statistic we have, traffic deaths. Finally, preventing drug driving is another enforcement priority under this Cole memorandum. Again, we see the number of traffic deaths related to marijuana in California increasing 20%. The last few years from 78 to 94 deaths. So doesn't this chart reflect this federal enforcement priority being undermined? And I assume that your question, the question's the same. You probably give me the same answer, right?
I think I would. I share your concern over the data. It's certainly alarming, and it's something we want to keep an eye on, and that's one of the reasons why we're embracing the recommendations of the GAO report, so that we can more accurately factor that.
I'll stop with this. Does the department plan to develop metrics as part of its response to the GAO's report? And if not, why not?
We're certainly going to, as we look at the data, we're going to develop, I think, a plan for which data we're going to be looking at. It is not likely that the department is going to be publishing to the states a description of when we are going to take action in a particular case. I think that is not helpful. Again, when we look at enforcement, we're going to want to look at a range of factors. We're going to look at local law enforcement. The analogy that I frequently use in California, I've been asked a lot by municipalities and counties that are considering their own ordinances. What if we enact this? Is this going to pass muster with you? Are you going to sue us? What if we pass this kind of a system? Is that going to be adequate? And I invariably tell them, you don't expect the state troopers to tell you in advance how many miles over the speed limit you can go before they're going to stop you. And my approach really is dictated by that. As a prosecutor, you want to maintain maximum flexibility to enforce federal law, and this data is obviously very important in making those decisions, but we're not going to say in advance that if you do X, we will do Y. We want to keep our ability to act in every case depending on the circumstances.
It seems to me, before I call on Senator Whitehouse, and this won't be a question, it seems to me when you talk about a range of factors, it's a far cry from the metrics that we need when the Cole memorandum says you're going to take action. Senator Whitehouse.
Yeah, I agree.
Thank you, Chairman. Mr. Wagner, and back in my U.S. Attorney days, it was kind of an article of faith within the Department of Justice that it was the department's policy to articulate on enforcement a single national standard for whatever, and that conditions on the ground in different states were not sufficient or not significant enough to justify any kind of explicit change or separation of certain states out from the prevailing national standard. I assume that that impetus remains very alive and well within the Department of Justice today?
I think it does. Obviously, U.S. attorneys jealously guard their prerogative to exercise their prosecutorial discretion. Different states are very different. In my 6.5 years as a U.S. attorney and serving on quite a number of committees, including the U.S. Attorneys Marijuana Working Group, I've really come to appreciate the very different situations that U.S. attorneys find themselves in around the country.
I both remember and well understand the significance, as does Senator Sessions, who had the same privilege, of being able to make one's own prosecutive decisions within the national guidelines that the Department of Justice maintained and did its best often to enforce against individual U.S. attorneys. My concern here is that now that operating principle of the department bumps up against a principle that has a long tradition in our country, which is of some degree of deference to states' rights, to decisions that have been made by sovereign states in their sovereign capacity, and what sort of deference is due there. And it strikes me that you're in a bit of a pickle, because on the one hand, you'd like to have a national standard. On the other hand, the national standard that would gratify the Attorney General of Nebraska, who is here, might be very different from that which would be appreciated by the Attorney General and the government of Colorado. So I guess my question to you is there a point at which the clear policy choice differences that states have made should create some policy differentiation within the department just as a matter of respect for local authorities. If not, it seems to me that what ends up happening is you have to, in Cole memos and other things like that, try to morph this peculiar national policy in a way that covers both, which the spread is covered by prosecutorial discretion, but when that spread is covered by prosecutorial discretion, we end up with a predicament you just elucidated, which is that your state partners, trying to proceed in good faith, can't get a straight answer from the department about where the real operating lines are. And I think that's a flaw. It may be that it's a less important flaw than departing from the principle of national homogeneity, but I'd really urge you to reflect on that, because I think that the principle of a single national standard has driven you to a place where you are not being as helpful as you could be to local officials who want clarity about how this is going to play out in their states. And waving the Cole memorandum at them, frankly, is not a very helpful answer.
So I think your observations about the tension between sort of our duty to enforce the law impartially nationwide and the variability in state responses to this issue in light of the sort of traditional federal-state relationship, particularly in drug trafficking, are spot on, and that is a tension which we wrestle with every day. On the other hand, I don't think that the Cole memo is as much a sort of departure from prior practice than some people have assumed. Traditionally, as I indicated in my opening statement, we do focus on the more aggravated cases, and that is true across the board in the narcotics world. And in that respect, the Cole memo is an effort to articulate what the more aggravated cases are that we would focus on. So we have discussions all the time with state and local drug prosecutors about what kinds of cases are you interested in prosecuting, what can we prosecute? And that's true in methamphetamine and heroin and every other way.
My point here, though, is that if the Cole memo reflects a retreat by the department to this aggravated cases standard, which is applicable without too much conflict in the legalized marijuana states, then in states that have not legalized marijuana, or in places where there is exclusive federal jurisdiction on military bases and reservations and so forth, then you've also retreated to aggravated as your standard there. And now what happened to the enforcement that people expected at something below the aggravated standard? And it looks to me like you're solving that problem with prosecutorial discretion and kind of letting that sort itself out, which may be the best solution for a while, but I think ultimately a little bit more rigor, a little bit more candor about how you work your way through that for your local law enforcement partners would be a useful outcome. I don't want to fault the department for where you are now. I understand why you got there, and I see the predicament. But I do think there's a little bit more of a partnership that is possible if you could be a little bit, if the department could be a little bit clearer about where this enforcement was, because there is a gap. It is a gap that's filled with prosecutorial discretion, and by definition, prosecutorial discretion is not a helpful, it's a black box and not helpful for partners who want to know what you're going to do and when you're going to do it, because that informs the relationship they have with you.
Just to flesh out that very thought, within California itself, so in California, we have had a medical marijuana has been legal, but until new legislation that was passed in January, there was no centralized regulatory system for that. So it was quite chaotic in California, and different counties and different cities took different approaches to it. Some banned it outright, some invited in marijuana producers. And so even within my own district, I cover 34 counties, different sheriffs, different police chiefs felt differently about the issue. And that changed over time. The California Supreme Court in 2013, around the same time as the Cole memo, made clear that local authorities could enact their own restrictions on medical marijuana, and many of them did so and then began enforcing it themselves, so they didn't need our help as much. So it has been a bit of a moving target, and because of that, I think there has been a considerable amount of a deference within the department paid to U.S. attorneys to collaborate with their state and local law enforcement and to take their views into account in the exercise of their discretion, and we do that really daily.
Thank you, Mr. Wagner. My time has expired. Thank you, Chairman.
Thank you. Senator Sessions.
Mr. Wagner, the issue is bigger than the technical matter we're discussing today, in my opinion. This is a huge, huge issue. I was United States Attorney when President Reagan was elected in the early 80s. Half the high school seniors in America had used an illegal drug. That over 12, 15 years went to less than half that, less than 25%. Would you say that was an advantage, a health advantage to young people in America, that drug use declined?
I will stipulate that certainly less drug use is better.
All right. What about marijuana legalization in Colorado? Did you take a public position on that?
I do not take public positions on political issues. I think generally that's a bad policy for U.S. attorneys. We try to maintain our role as the enforcers of law, not the makers.
Been there. I know the tension on that. But in the past, U.S. attorneys, the drug czar, has opposed it. Does President Obama oppose states adopting legalization of marijuana?
I don't know exactly what positions he's taken with respect to Colorado and Washington.
That's a terrible comment. That the United States Attorney that works for the President of the United States does not know whether he opposes or favors legalization of marijuana. He certainly has said some things that indicate he thinks it's a very little problem. But these data show that it is. So you got this huge increase in marijuana-related emergency room visits. This is as obvious as night following day. You make more marijuana, more available. You basically say it's not very dangerous and that young people have a right to participate with it, and others, older people do too. You're going to have more problems, wouldn't you agree?
I certainly think that increases in marijuana use are bad and for public health. I totally agree with that. And I think there's been an increase recently. Certainly here out in Sacramento, my district, our focus is on opioid and heroin increase, which has been quite an unfortunate upturn in overdose prescription pills. I know in the Sacramento area, just in the last 10 days, we've had 9 people die from fentanyl overdoses, and that's something which we are.
Heroin or just fentanyl?
No, not heroin. They are apparently prescription drugs that have been laced with fentanyl, and that is something that we've been spending sort of 24/7 the last
huge
few
issue,
weeks.
But just from my experience in dealing with this, we need to set a nationwide understanding about the problem. This is very real. Are you aware that the American Medical Association just last year issued a report that hammered this idea that marijuana is not dangerous, and they were particularly concerned about the mental impacts it has on young people? Are you familiar with that?
I am.
Do you have any doubt about that?
I don't have any doubt about that, Your Honor.
Did the drug czar of the United States of America make any express any opinion to Colorado about the possible dangerous impacts of marijuana legalization in Colorado?
I know the drug czar has been quite articulate about some of the dangers associated with marijuana. In fact, Mr. Botticelli, when he was just before he became drug czar, came out to California with us and participated in some marijuana enforcement operations where we went up into the North State, flew over some very large marijuana grows in the course of our operation. So I know he's been quite committed to supporting us. In fact, he supported an expansion of the HIDA to do more enforcement in our district on marijuana.
Well, what I want to just say to you and to those who might be listening is it's far more important than just the details of whether federal prosecutors start prosecuting marijuana cases in Colorado. Colorado was one of the leading states that started the movement to suggest that marijuana is not dangerous. And we're going to find it, in my opinion, ripple throughout the entire American citizenry, and we're going to see more marijuana use, and it's not going to be good. We're going to see more other drug use, illegal drug use also, which is damaging. I mean, we need grown-ups in charge in Washington to say marijuana is not the kind of thing that ought to be legalized. It ought not to be minimized, that it's in fact a very real danger. You can see the accidents, traffic deaths related to marijuana jumped 20%. These are the kind of things that we're going to see throughout the country, and you'll see cocaine and heroin increase more than it would have, I think, had we not talked about it. Well, is there any sense that Colorado might reevaluate what they've done?
I know that there is a lot of discussion back and forth between the U.S. Attorney's Office and the state authorities in Colorado about issues that we're seeing, issues that we're concerned about, and I understand that the state authorities have been receptive to our concerns. I don't know the details of what they're doing about them, but citing some of the data that Senator Grassley presented earlier, we're concerned about that data, and we're talking to Colorado about it. I know the same is true in California.
I hope you'll speak out. I mean, you're able as a citizen of Colorado to say you think this is dangerous. I work with it every day. I see the danger and damage it does, and I think the president needs to speak out. I think one of his great failures, it's been obvious to me, his lax treatment and comments on marijuana. It's been obvious. It reverses 20 years almost of hostility to drugs. It begun really when Nancy Reagan started the Just Say No program. I made that mention when she passed away. It was a great accomplishment. We moved this country from 50% of high school seniors using a drug, marijuana or other drug, to less than half that. Lives were saved. Young people's futures were saved. And if we go back into this path, we're going to regret it. And you got to have leadership from the top. And I think the drug czar and the DEA leadership understand this. But I'm not sure the president does, and not sure the message is getting down to the prosecutors. Mr. Chairman, thank you for hosting this. You've been very astute on this issue for many, many years. You've led this committee, this drug caucus, for many, many years. We made tremendous progress. And I can't tell you how concerning it is for me emotionally and personally to see the possibility that we would reverse the progress that we've made and let it slip away from us. Lives will be impacted, families will be broken up, children will be damaged because of the difficulties their parents have, and people may be psychologically impacted the rest of their lives with marijuana. And if they go on to more serious drugs, which tends to happen, you can deny it if you want to, but it tends to happen, there'll be even greater causes.
I can assure you that we're very, I'm a citizen of California, and certainly out there, we're very aggressively prosecuting narcotics cases. I had a press conference last week in a interstate narcotics trafficking case. We prosecuted almost 90 people on marijuana cases in my office last year, and one of my assistant U.S. attorneys in February received the National Prosecutor of the Year award from the HIDA National Association at their national conference here in Washington for her work in marijuana prosecution. So we are very committed to doing those cases, and we'll continue to do that.
Thank you. I would just comment that, as I was talking to somebody who's experiencing this recently, it was a prevention movement that really was so positive, and it led to this decline. The creating of knowledge that this drug is dangerous, you cannot play with it, it's not funny, it's not something to laugh about, and trying to send that message with clarity that good people don't smoke marijuana. And the result of that is to give that away and make it socially acceptable creates the demand, increased demand that results in people being addicted or impacted adversely. I just hope that we can get our thoughts together on it. I believe the Department of Justice needs to be clearer. I believe the President really needs to reassert some leadership on this. I think it's really serious.
Ms. Grover, I just have one question for this panel, and it's for you, and then I'll call the second panel. The department now apparently concurs that the GAO's recommendations, after officials first told your agency that they didn't see the benefit to DOJ's documenting its monitoring of state marijuana legalization. Can you provide us with a status update on what you know about DOJ's implementation of the recommendations? For instance, when would you expect them to be fully implemented?
They sent a note late on Friday with an update on their progress in that regard, that they're committed to creating a monitoring plan, and that they have asked the Executive Office of the U.S. Attorneys, the Attorney General Advisory Committee, and the Criminal Division within the department to work with them to develop the data that they need to have. I think they're just starting, and I expect it will be quite a while. This is a big job for the department, but it's critically important because good, solid metrics, as you mentioned, as Senator Sessions mentioned, is really the underpinning of all of the decisions that will need to be made going forward.
Okay. Go ahead.
I think I can elaborate on that.
Go ahead.
Exactly as Ms. Grover indicated, we are moving to collect the data. I've personally participated in a number of meetings and conference calls about this, including yesterday, last week, and prior to that, involving the Criminal Division, EOUSA, as Ms. Grover indicated, DEA, people from the OCDF program. So there are a lot of people mobilized within the department to make this happen. As she indicated, this is a heavy lift. All of the people who are going to work on this have to make space on their plates to do this. But we are identifying the data that we need, the people that are going to make it happen, and we're committed to making it happen as soon as we can. But I agree with Ms. Grover. It's going to take us some months to make it a reality.
Okay. Thanks to both of you. I'll call the second panel now. Thank you.
Thank you, Senator.
Thank you. While the other panel is coming, I'm going to introduce them. Doug Peterson was elected Nebraska 32nd Attorney General, 2014. In this capacity, Mr. Peterson represents the state of Nebraska in all litigation matters. Nebraska is one of 2 states that sued Colorado in 2014 as a result of the diversion of marijuana across the border into Nebraska. He received a bachelor's degree from the University of Nebraska and his law degree from Pepperdine University School of Law. Our second witness and final witness, Dr. Catherine Wells. Dr. Wells has served as the medical director and team leader of the Denver Health Medical Clinic at the Denver Family Crisis Center, and I think you've been in that position since 2003. Dr. Wells is a graduate of Carroll College, Helena, Montana, and Creighton University School of Medicine. She's certified in both general pediatrics and child abuse pediatrics. I will call on the Attorney General first.
Good morning, Chairman Grassley. I want to thank you. It's an honor to testify before you today, and I appreciate your attention to this critically important issue of the growing state-sponsored marijuana industry and how it violates federal law. Frankly, it's amazing to me that this one memo issued by the Department of Justice in August of 2013 has resulted in a marijuana industry that has become completely untethered from the anchor of the Controlled Substance Act. Media reports indicate that marijuana industry has earned over $5.4 billion in 2015. And although I agree with the GAO's basic conclusion that the Department of Justice has failed to sufficiently document its monitoring efforts, the magnitude of the Cole memo on the marijuana industry is so much more significant than simple issues of paperwork. The Cole memo identifies 8 enforcement priorities for federal prosecutors. For the sake of time, I want to only address the first 3, that being distribution to minors, revenue sales by gangs, and diversion to other states. As to minors, in the last year, I've had the opportunity to speak to several Nebraska high schools, particularly in western Nebraska. In fact, I'll be there tomorrow morning speaking to another school. I've learned from school administrators that students have taken a much more accepting and less guarded attitude towards marijuana. School administrators frequently hear students say, if it's legal in Colorado, it can't be that bad. However, the free market factors in Colorado have caused marijuana potency levels to have reached unprecedented heights, posing serious health threats. The marijuana of the 60s, 70s, 80s, and 90s had THC values around 5%. Currently, the free market out of Colorado has potency in the 15 to 20% THC level, with premium values over 25% THC. Also, the edible cannabis products put in such things as pixie sticks, lollipops, power drinks, and gummy bears, obviously targeted towards young people with serious levels of THC. Law enforcement officers throughout the state of Nebraska have reported seizing these type of edibles from several minors in the state. As to gangs, these extraordinary high potency levels have increased interest by drug traffickers and by violent gangs in the Omaha region. The Omaha Police Department reports to me, and this I think would also be true for your community of Council Bluffs, that prior to 2009, the primary source of marijuana in the metro area was Mexico, and that the value of that product was typically about $1,000 a pound. In 2009, once Colorado passed its medical marijuana, or not passed, but after the Ogden memo, and it became much more commercial, the marijuana being produced in Colorado was soon being transported into Omaha and becoming the marijuana of choice. The price of marijuana shot up to $3,500 to $4,200 a pound, and that tells you how significant this potency issue really is. It also, with that type of value, brought in the gang activity. Omaha Police Department reports that since 2014, now they typically see Colorado as the predominant supplier of marijuana to the community. And also the new twist is that the internet and social media are more frequently used to sell to Omaha from Colorado using the Postal Service, UPS, and FedEx. Most importantly, the Omaha Police Department reports that with these high potency, high demand for the Colorado marijuana, that they are seeing more frequent violent and firearms related to the marijuana trade. Finally, on diversion, the diversion of marijuana into Nebraska has been fierce. For example, just mid-January to the end of February of this year in Lancaster County, which is an eastern county of Nebraska, it's where Lincoln is located, there were 3 significant stops. One stop along Interstate 80 was for, they found over 1,500 pounds of marijuana. It's believed that that marijuana was brought from Oregon. That has a street value of approximately $6.5 million. There was another stop where 515 pounds. Now, this is just one county within 40 days where 515 pounds were seized. This marijuana was sourced to Northern California. And another 100-pound stop, which was believed to come from Colorado. So over 2,000 pounds in 40 days with a value of over $6 million. It's obvious that the diversion is rampant. I think the NIDA report, the Rocky Mountain report, certainly indicates that several states are receiving the Colorado marijuana. It could be Colorado, Washington, Oregon, or California. There's no question this industry is growing. In conclusion, the irony of all of this, the harm to minors, the revenue generated by gang activity, widespread diversion among the states, were all clearly identified by this body back in 1970 in the passing of the Controlled Substance Act. The social harms and the importance of the Controlled Substance Act was confirmed by the Supreme Court in 2005 in the case of Gonzalez v. Raich related to California medical marijuana. In spite of the powerful wisdom of both this body and the U.S. Supreme Court, the marijuana industry has been allowed to take the Cole memo and has ignited a marijuana market that has spread like wildfire beyond the Colorado borders. In conclusion, to the Caucus question, is the Department of Justice adequately protecting the public from the impact of state recreational marijuana legalization? The short answer is no. The solution is far more involved than the recommendation of the GAO. As Nebraska's Attorney General, my greatest concern is that the high-profit industry is being allowed to market without restraint an extremely potent drug that continues to get stronger. The target market is our youth, who stand most to be seriously harmed. And much like the tobacco industry and Joe Camel, it's very clear that this industry is targeting those young people. As elected officials, this is on our watch. None of us want to look back 10, 20 years from now and say we could have done more. It will be far too late. The industry is running far too hard. The wisdom found in the Controlled Substance Act is amplified as marijuana has become so much stronger. Protecting against these serious public health risks was and is at the heart of the Controlled Substance Act. This body This body cannot let the Controlled Substance Act be completely circumvented by one agency and one memo and an industry that has absolutely no concern for our public health or our youth. Thank you.
Thank you, General Peterson. Now, Dr. Wells, please.
Good morning, Chairman Grassley. Thank you so much for providing me the opportunity to appear before you today to discuss my perspective of the impact legalization recreational marijuana has had on Colorado's children and child welfare system. As a child abuse pediatrician and someone who has observed and studied the impact of substance abuse on children and child maltreatment for almost 20 years, I'm hoping that my experiences related to marijuana legalization in Colorado might help inform your decisions. In Colorado, we have come to understand that these are extremely complex issues that seem to generate more questions than answers. Most of my comments can be viewed through the Department of Justice's marijuana enforcement priority of preventing distribution of marijuana to minors. Regardless of one's overall position on marijuana legalization, I trust most would accept this priority. Unfortunately, child health and welfare in Colorado has been endangered for many reasons, but largely because of skyrocketing access to marijuana edible products. Marijuana-infused products such as candy, brownies, and cookies are all inherently appealing to children. Because of this appeal, better regulations around edibles is essential to prevent child ingestion. A systematic literature review of unintentional marijuana exposures in children undertaken by Colorado's Retail Marijuana Public Health Advisory Committee found substantial evidence that more unintentional marijuana exposures of children occur in states with increased legal access to marijuana. According to data compiled by the Rocky Mountain Poison and Drug Center, the number of marijuana-related exposures in children's ages 0 to 5 increased from an average of 4 per year during pre-commercialization years of 2006 to 2008 to 13 per year during post-commercialization between 2009 and 2012, a 225% increase, to an average of 31 per year following legalization in 2013 and 14, a subsequent 138% increase. In this same time period, between 2013 and 2014, the average percentage of all marijuana-related exposures occurring in children ages 0 to 5 in Colorado was 17.71%, far exceeding the national average of 5.95%. Because of the increased potency of these exposures, children are often requiring more medical interventions when they do present after an ingestion. According to Colorado Hospital Association data, the rates of hospitalizations and emergency department visits of children up to 9 years of age due to possible marijuana exposures increased more than 5-fold between pre-commercialization and post-commercialization. In addition to the clear health concerns, child ingestions prompt reports to child welfare and law enforcement, posing additional challenges to systems that then attempt to determine the source and nature of the exposure, whether it was intentional or accidental, and the potential for future risk. Beyond access to edibles, Colorado has experienced several other challenges related to the impact of legalization of marijuana on children that we are trying to understand more completely, but are clearly hindered by lack of data. For example, home cultivation of marijuana, including home grows and processing of edibles, has raised concerns related to children. While we now have restricted the ability to legally extract THC utilizing butane due to risk of explosions, other risks continue to exist, such as those from improper ventilation, exposure to pesticide, and unrestricted access to marijuana. Marijuana legalization has also had a sizable impact on our schools. The Denver Post examined marijuana store locations and found 25 marijuana stores closer than 1,000 feet to at least one nearby school. And using data compiled by PBS in Colorado, there are signs that more students are using marijuana, creating an increasing problem for teachers, counselors, and other school personnel. Another challenge is the ability to determine if someone is impaired while operating a vehicle or parenting, whether the use of recreational or medicinal. Impairment is an important issue in determining if a caregiver is safe to care for a child, a decision that challenges child welfare workers daily. A final topic I wish to touch on briefly is marijuana use during pregnancy and breastfeeding. The legalization of recreational marijuana has underscored the need to better understand the impact of exposure on the unborn fetus as well as the breastfeeding infant to different forms of marijuana. The potential for adverse outcomes in exposed offspring of marijuana-using mothers prompted Colorado's Retail Marijuana Public Health Advisory Committee to review the available literature on physical, developmental, and mental health outcomes of marijuana exposure during pregnancy and breastfeeding. While it is important to note that this literature is based on smoked marijuana alone, as well as much lower potency THC than is being used currently, the committee found moderate evidence that maternal use of marijuana during pregnancy is associated with negative impacts on associated exposed offspring, including cognitive function, IQ, and attention. Importantly, these effects may not appear until adolescence. The committee also reviewed the very limited research related to breastfeeding and marijuana and found biological evidence shows that THC is present in breast milk of women who use marijuana and that infants who drink breast milk containing THC absorb and metabolize the drug. The issue of prenatal exposure of marijuana has been especially challenging because in Colorado, an infant born positive for a Schedule I drug or Schedule II drug not being used by mother is prescribed is defined as child abuse. Therefore, an infant born positive for THC in Colorado meets the healthcare provider's mandate to report the case to child welfare and can be used as evidence of child abuse in civil court. Due to the many challenges faced by Colorado's child-serving professionals, the Colorado School of Public Health has undertaken a health impact assessment. This effort was largely initiated due to perceived inconsistencies in how marijuana use and exposures were operationalized in child welfare in an effort to define greater consistency and develop evidence-based and informed recommendations. This challenging work continues specifically related to mandatory reporting, child welfare screening and assessment, and management of open child welfare cases where marijuana is a factor. In conclusion, I urge the federal government and other states contemplating similar legal changes involving the legalization of recreational marijuana to take time to consider the impact such changes will have on the health and well-being of our youngest citizens. We desperately need better and more accurate research and data, funding support, and laws that allow research and needed to inform these critical policies and regulations that clearly impact the health, welfare, and safety of our most vulnerable but our most critical resource, our children. Thank you very much for your time.
Yeah, thank you both very much. I've got a couple questions for General Peterson and then a question for you, Dr. Wells. My first question you've already answered with a lot of specifics. But let me ask the question anyway, and it'll give you a chance for maybe some additional information or conclusions that you can have an opportunity to present. We all know that one of the federal priorities outlined in Cole is preventing the diversion of marijuana from states where it's legal under state law to other states. So the question I was going to ask that you've already answered, but gives you a chance to expand. What does the available information tell us about how readily marijuana from Colorado is being diverted to other states, and specifically what has been the experience of Nebraska law enforcement officials in this regard?
You know, Senator, it's been very, very difficult. It used to be initially thought that western Nebraska was taking the impact being so close to Colorado. And now it's across the state, and I'm sure in your state of Iowa it's moving that direction. It's a very significant strain to the financial abilities of several of these county law enforcement agencies. They make a lot of stops along I-80 and some of the other off-roads. The other problem is they're seeing it in the high schools. They see the young people bringing the drugs in. There is an example of a fairly small county, population 2,000 in western Nebraska, just to give you a snapshot. In 2011, they had 3 felony charges with regards to marijuana, and that was most likely medical marijuana out of Colorado. After 2014, or after the passage in 2013, they had, in 2014, they have, I believe, 33 citations. For a county of 2,000 and having to prosecute 33 felony marijuana cases is a significant impact financially. They don't have the resources. They barely have the resources in a lot of these counties just to get by with their burdens. And when we add to this the traffic of marijuana that's coming through, not only passing through the counties, but also within the residents and the young people in the counties, it's put quite a burden on them.
My next question is about Article 2, Section 3 of the Constitution, requiring the executive to take care that the laws are faithfully executed. Of course, this duty is also subject to the exercise of legitimate enforcement discretion due to limited resources, as only one example. Do you believe the Department of Justice enforcement policy laid out in Cole Memorandum is consistent with the take care clause? Why or why not?
Senator, what amazes me about the Cole memo of 2013, it was a green light to the industry to take off, and the industry has certainly taken off, and with certainly an attitude that they don't have to worry about the Department of Justice. Hearing the testimony today, it's a little bit like a whack-a-mole type of analysis by the Department of Justice. by issuing the Cole memo, they opened the valve, and this water is flooding into Nebraska. And then their answer to opening the valve is, hey, we've got really big buckets, and we'll come and help you out. In fact, on 2 of those cases that I've mentioned, the 1,500 and the 500, the U.S. Attorney's Office is becoming involved. But that makes no sense to open up the valve and then say they're going to show up with the big buckets to help you out. Our position is that they need to stop it in Colorado. And it makes no sense to say, well, we'll use this discretion as set forth in the Cole memo when we know, and the biggest concern I have is we know that our young people in Nebraska, and I appreciate the comments by Dr. Wells, we know our young people are getting the drugs. And the feds can't stop that because it's not large enough to them. But yet, I can tell you story after story of young people who've had the ability, either through a sibling or someone else going to Colorado, high school students gathering up their money and sending a buyer into Colorado and bringing the edibles back or bringing the product back, and it's a very, very strong product. So this Department of Justice perspective just doesn't make sense to me. It doesn't seem to be good uses of resources because they've opened up this big industry, and the industry, the free market, has relished it. The one thing I would also comment, Senators, I don't think the Department of Justice fully understood how the free market works. When you tell an industry that you have a green light to go forward, what's that industry going to do? They're going to try to make the best product possible. And by doing that, now we have these potency levels, 20, 25% in these different edible products. We have a real public health concern. I think they assumed that this was going to be the old days, 5% marijuana, and it's not going to be a big deal. The fact of the matter is, it is a serious public health issue, which was addressed back in 1970 under the Controlled Substance Act, recognized by the Supreme Court in the Raich case, and its interstate commerce impact. And now, if they don't do something very quickly, I don't think we'll ever be able to get this back in the bag. And that's why I think, frankly, this body, with its Controlled Substance Act, is being ignored. And I think with the separation of powers, I believe this body needs to step up and say, you know what, we meant it. We meant what we said in the Controlled Substance Act, and it's truer now than ever before. I appreciate Senator Sessions' comments on that. This memo has created great havoc, and I can't believe the industry has been allowed to run so freely, make so much profit, and at the cost of public health and particularly our young people.
Thank you, General. Now, Dr. Wells, another one of the Cole memoranda, federal enforcement priorities is preventing minors and children from contact with marijuana. Now, you've noted edible products pose a risk to children in Colorado, but data on what is happening is limited. So could you walk us, I have 2 questions, let me state both of them. Can you walk us through what information exists on how the presence of edibles has impacted the federal priority of protecting children in Colorado? And then going forward, given the very complex issue we have here, what sources of information would you advise the Department of Justice to look into in order to monitor what is happening more than what they are now?
Thank you, Chairman Grassley. I mean, I think that the best information that we have is things like the Colorado hospital data, and so if there's an ICD-9 code that someone's come in and they're tested positive, almost always it's assumed that it's an ingestion of an edible. Sometimes it's because there's actual evidence of an edible exposure. Sometimes it's based on how the child may have gotten into something. The Poison Center data is somewhat limited, so what that means is if I'm a physician and I'm in the emergency department, I see a dangerous exposure or ingestion of some kind, I may call Poison Center to get some advice. Quite frankly, those numbers are going to start to decline, and we've seen that because people are getting more comfortable because we're seeing this more frequently. So if I'm comfortable treating a child that's been exposed, I'm not necessarily going to call Poison Center. Those are really the 2 best sources. In child welfare data, there's no way to pull out data about referrals that come in regarding an exposure or an ingestion from marijuana, and that's very frustrating and challenging to those of us that are making policy. I think that anything that could help us gather better data. We certainly learn from what other states are doing and other folks' experiences as well. So it's like in medicine, we talk about a case study being somewhat helpful, but then something that really is much more broad in its interpretation and understanding of what the actual data is very, very helpful. So First of all, the federal government, I think anything that can draw data down from not just our Colorado experience, but other folks that are experiencing these same issues would be very helpful in determining policy. Additionally, when we try to address these issues and questions and try to develop policies and regulations around these issues, frankly, the huge amount of money that comes in from marijuana industry and the influence that has on those conversations takes a conversation that really, from a health perspective, seems to be a very simple and basic conversation, and frankly makes it a very political one, and one that has a significant interference in making reasonable policies.
Well, thanks to both of you. I appreciate your participation and your preparation for today's meeting and the work that you respectively do. We had 4 of all the members of the caucus here. I don't know to what extent there'll be questions in writing, but if they would, and I should have told the first panel this as well, if you would, we'll have the record open for a few days for take written questions, and if you get some, please answer them. Outside of that, I say thank you and meeting adjourned.
Thank you.